Pre-charge engagement is the process that takes place after someone has been interviewed at a police station under caution, and rather than them just sit tight and wait for an investigation to take place, it's open for them to instruct lawyers who can then engage with the investigators, and it's the opportunity for the defence to go on the front foot rather than do nothing and allow the prosecution or the investigators to get on with their investigation, submit a file to the Crown Prosecution Service, and for a decision to be made. So with pre-charge engagement, the defence team can approach investigators and then suggest lines of inquiry that may be useful for the defence and for the purposes of the investigation. And the whole process from a defence perspective is ensure that it's much more two-sided and that the appropriate and right decisions are made at the end of the case. And what flows from effective pre-charge engagement is representations against charge. And that's where the defence will make representations to investigators and ultimately to the Crown Prosecution Service, arguing that in accordance with what's known as the charging standard, there is not either a realistic prospect of a conviction or that a prosecution is not in the public interest. All prosecutors, whether from the Crown Prosecution Service or other prosecuting authorities, are bound by the Code for Crown Prosecutors and specifically the charging standard. And under the charging standard, there are two tests that have to be met. Firstly, there must be a realistic prospect of a conviction. In other words, the case must be strong enough. And secondly, a prosecution must be in the public interest. And if those two tests are met, then a prosecution can commence. And it's the role of the defence during the pre-charge stage of the case to persuade, make representations to the Crown Prosecution Service that there is not either a realistic prospect of a conviction or that a prosecution is not in the public interest. There's an awful lot that can be done to prevent a prosecution. Following an interview at a police station, it's crucial that the defence look at everything that can be done to contradict or undermine what is being alleged during the police interview. And it's at that point, once that preparation has been done, that the defence would seek to become involved in pre-charge engagement with investigators and look at all the weaknesses in the prosecution case. And once that's done, then effective representations against charge can be made, arguing that the charging standard is not met, there's not a realistic prospect of a conviction, or that the prosecution is not in the public interest. It could be messaging between parties, it could be social media activity, it could be material in the possession of third parties such as courts, counsellors, hospital medical records, school records, it could be CCTV evidence, it could be witnesses, character witnesses or witnesses to an alleged incident. The list is not exhaustive, and the message at Olliers Solicitors is, if you as a suspect have got something that you want to draw to our attention, then tell us about it and we'll make the decision as to whether it can be used on your behalf. Bail conditions can be varied quite informally by liaison with the investigating officer. That would require consent, and if that can't be obtained, it can be done by way of an application to the courts. Investigations can vary in length depending on the allegation under investigation, the police force investigating it, and the material that needs to be looked at by the police. Wherever possible, we will do whatever we can to accelerate the process, but our ultimate objective is a successful outcome for our client, which means no further action is taken against them. Instructing Olliers following representation by a duty solicitor at the police station is the easiest thing in the world. We frequently act for clients who've been represented by the duty solicitor and then come to us because they want a proactive approach to their investigation. The public funding available for this area of work is very limited, and it would not allow Olliers to undertake the work that we need to do for effective pre-charge representation.